I am starting the recording now, so they don't have to worry about that. And for those of you who just joined, I'm Sue Osthoff with the National Clearinghouse, and I really want to welcome all of you. This is the 14th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. And if you missed any of the earlier ones, they're up on our website, and so you can sign in and see those or participate in those in that way. I mentioned earlier that we're going to be collecting questions in the chat box, and we're going to stop during the presentation once or twice to ask those questions. So we really want to get as many questions to our presenters as we can as time allows. And before I go any further, I just want to thank the Office on Violence Against Women for the support of this project on expert witnesses. And we just think it's really great that they have been supporting work about this topic area. So thank you very much, OVW. So you're probably aware today, it's up on the screen, that today's webinar is titled Preparing for Your First Case as a Domestic Violence Expert Witness. And now I'm going to hand it over to my coworker, Cindine Pizzell. She's our legal coordinator here, and she's the lead staff on our Expert Witness project. And she's going to introduce our speakers and let you know a little bit about the format for today's webinar. Thank you.
Thank you, Sue. Hello to everybody across the country. I'm so glad you're joining us here today. As Sue mentioned, we have two wonderful trainers and speakers here to talk with you. I'm going to briefly introduce them, but if you see the slide that's on your screen right now, you can read a more full bio of each of them when the training is over. So Scott Miller has been doing work in the women's movement for over 30 years, and he's been with the Domestic Abuse Intervention Project since the year 2000. He coordinates Duluth's Coordinated Community Response to Domestic Violence under a project called Blueprint for Safety. He trains nationally and internationally on the components of the Duluth model of intervention, and he's also a forensic interviewer for First Witness Child Abuse Resource Center in Duluth. He trains nationally on how to conduct interviews with children and work from a multidisciplinary team approach into the investigation of child abuse. He works independently as an expert witness in both civil and criminal trials to explain how the tactics of abusers and associated risks generated by battering are linked to counterintuitive victim behaviors. So that's Scott. Melissa Scaia is here as well, and she's the executive director of two different agencies in Minnesota, the Domestic Abuse Intervention Program and Advocates for Family Peace. She's also a consulting trainer for a number of national organizations on domestic violence and child abuse, including Praxis International and the National Council of Juvenile and Family Court Judges. She's been selected for her expertise to participate in numerous roundtable advisory discussion groups for the Office on Violence Against Women, to the National Judicial Institute on Domestic Violence differentiation, on custody, and on betters intervention programs. Melissa also works independently as an expert witness, and both Scott and Melissa have testified in numerous cases over the past several years. And I'm very pleased to introduce them to you here today and excited to hear what they have to tell us. Thank you.
Okay, Cindine, it's Melissa. Do you want us to get started?
Yeah, thanks.
Okay, great. Thanks, Cindine. So first, I just want to say that Scott and I are here right now, and we are actually in Washington, D.C. We want to thank the National Network to End Domestic Violence. They're allowing us to use one of their office spaces here, so thanks to NNEDV. Scott and I are here for the United States of Women, the White House Summit on Women and Girls that's happening here in Washington, D.C. tomorrow. So we're thankful we're not relying on a hotel's internet connection, because those can be sketchy. So we're thankful to our friends here at NNEDV for letting us use their space, and Sue and Cindine and Dot for helping coordinate that. So you gave an introduction of us, so we're going to get started, say a little bit more about ourselves, kind of how we came to do this, and then talk about what's on the slide a little bit. So Once again, I'm Melissa Scaia, and I came to do this, and I was trying to remember the year it was. I think it was 2006 when I looked back. So I think it's been 10 years now. And the only reason I remember is because I remember I had, a 1-year-old son at the time. I got this, my last child was born in 2005, and I got a call from Rhonda Martinson. Many people may know Rhonda. She's a trainer for prosecutors on violence against women. And she got a phone call from a prosecutor in the state of Minnesota at Stearns County. Some people might know Stearns County's work. They do some national trainings related to domestic violence courts. And so Janelle Kendall, who is the lead county attorney there, and some of her assistant county attorneys were looking for someone to do expert witness testimony in a domestic assault case in the state of Minnesota. And so Rhonda had called me and asked me if I would consider it. And I said yes at that point and started the discussion with the prosecutor. There were 2 prosecutors early on, Sarah and Mariel. At the time, Mariel's still there, and so we've been doing that now off and on for 10 years. But what happened after the first expert witness case was that the requests just became quite numerous. And so, and they're still quite numerous at this point. I mean, we'll talk more about this, but I just want to say that as a heads up for those who are thinking about doing this, is that once you become an expert witness in your community, in your state, and it becomes successful, the number of requests you get will just exponentially grow from there. And so I knew that I couldn't keep up with the demand at the time, and I had been training nationally at that point just a little bit with Scott Miller, and so I had reached out to Scott. I don't even remember what year that was, but he can talk about that. But I reached out to him to ask him if he was interested in doing it. So because there weren't many other people. There's one other woman that we ended up finding out at the time in Minnesota that had done expert witness testimony. So for a while there was 3 of us, and now I think it might be just Scott and I. We're doing it on a regular basis anyway. So that's just a short introduction to how we came to do this. So I'll let Scott say a little bit more about himself.
Yeah, so one of the things that when Melissa asked me to do this is, the obvious anxiety of sitting up in front of court, testifying, and being the focus of the defense's attack when you're testifying on behalf of the state. And so I wanted to know as much as I could about what I was going to do before I did it. And so I learned a lot from Melissa about hearings. We're going to talk a little bit about the how to get qualified as an expert. And so I was versed in what was going to happen there, and I was prepared for it when it did. But one of the things that I did that I thought was really helpful to me is when I worked for First Witness Child Abuse Resource Center, there was a defense attorney who was part of the team. And so I had a good friend who was a prosecutor, I had a good friend who was a defense attorney, and I asked them both, after I'd kind of put together an idea of how to talk about myself, my work, in a qualifying hearing, I asked them to just grill me, to just do their worst. And it really helped me figure out how to edit myself, the kind of answers that I was giving, how to think through them, how to provide examples when appropriate, when it's typically not appropriate, when it's a yes and no kinds of questions. And so it really helped me just understand court speak, which is if you sit and you watch court enough, you understand. Not everybody. There's a language there and there's a pace of things that's different than in normal conversation. So that really helped immerse me in that space that I was going to walk into and feel a lot more confident prior to doing it. Typically, when I talk to people about doing this, or they come and ask me, I've been thinking about doing this, the reservation is those things. I don't know what the objections are going to be. I don't know how they're going to attack me. I don't know how to really explain what I do. they can't picture what it is. And so if there's a way to go in and watch a trial, for example, and just see how that goes, again, you'll understand the environment that you're walking into, and I think that really helps reduce some of that anxiety that you can have coming in.
Great. So we're going to just start by talking a little bit about what are the goals of expert witness testimony, because you have to think a little bit about, what is the gap or area in which an expert witness is going to fill as part of their testimony. And so this term came out when I first started this, and Rhonda Martinson taught me about it. She referred me to a woman named Jennifer Long, who worked at the National District Attorneys Association. And we have a link to this at the end of our slideshow, but it's a monograph that Jennifer had written about the use of expert witnesses in cases of domestic violence. And I believe also it's regarding sexual assault as well. And so I early on spent time just reading that entire monograph. It's a monograph that was funded by the Office on Violence Against Women. It's very well done. It's very helpful. And then what I did is I called Jennifer Long, and I called her before I testified about whether I should, whether I should say yes or no to it, to Rhonda's request in Stearns County, and then talk through with her about whether I should, would be considered an expert or not. The trick is a little bit, of course, is that, it's a little bit dependent on your state's law. And of course, Jennifer, of course, steered me to that direction to look at what it meant. So I then also called our local coalition. I called the Minnesota Coalition for Battered Women. I called the director there, Liz Richards, and I remember talking with her at the time as well. But this word counterintuitive is a word that, is used in that monograph, and then is one that's used to sort of describe the gap that's happening in the courtroom. So essentially what you have is that you have the actions and the behaviors of the victim of domestic assault, and it's a term that's used in Minnesota, domestic assault. And then you have what would be known as the jury, or the public's general understanding of how a victim should act. And so basically what you have is a gap. And so it's, to a jury, counterintuitive is another way to say it just doesn't make sense to them. Like, well, I don't understand, why would a victim do this? Or why would a victim do that? And so essentially what an expert witness does is helps them fill that gap and that understanding, to understand why a victim is acting and behaving in the way in which they are. And so that's what one of the biggest goals of the testimony are. Now, prosecutors, when they call you, they will describe that in a number of ways. And so we just have some of those listed here. For example, I know I've testified in a case where it was delayed reporting. Why did the victim not report, what had happened, or why was the timeline so long, for example? Recantation is a term that gets used a lot with prosecutors when they call, of course, meaning that initially on the day of the incident, the victim said this occurred, and then maybe now 3 days or 3 months or 30 days later is calling the police, calling the prosecutor, saying essentially that didn't happen that way. I'm recanting, or saying that it happened differently than I originally said. And then, of course, the last one, that's the most common one, is when she decides to stay with or maintain a relationship with the man who batters her. And so those are kind of the most common reasons that prosecutors are going. There are some others that we'll talk about. We just want to let you know these are by far the most common. And so just to give you an example, in Stearns County and in St. Louis County is where Duluth is, where Scott and I both work. And in those two communities in particular, it's, for the most part, now in nearly every case, the prosecutors are putting in mine or Scott's name as an expert or as a witness in the case. And so now it's just become part of their institutional practice that they're using experts, and these are sort of the most common reasons they're doing that.
Okay, so the reason you're hearing a little bit of a delay is because we're both in the same room. As we have to take our headsets out, mute our phones, and then so there's a little delay there every time we do that. So the context for understanding the decisions a victim of battery makes, this just builds a little bit more on what Melissa was talking about. One example was there was a case where the person had the man who was battering had been violent the entire marriage, and it wasn't until decades after experiencing all of this abuse that she called 911, and there were adult children who testified against her, saying that she was the problem, and so the prosecutors got this thing. How do I explain this to the jury that she's just not making this up? And so I don't know the facts of this case when we're preparing, but she's asking me questions that, to some extent, I understand that it must be based in some fact in the case. But she asked me, what's my explanation for that? And in a Reader's Digest version, when kids grow up in a home where they've seen their mother be blamed constantly for everything that goes wrong, every time there's discord, every time something doesn't work right, every time the dinner isn't made right, it's her fault. And it's a narrative that these kids constantly would hear growing up. And there was never any account for that. There was never any law enforcement involvement. And when finally that happens, and all of this fallout from getting arrested, and you're a prominent figure, and the consequence to them looks way more out of balance to what actually happened, because it's all they've ever known. Now, I didn't know if that was, the facts of the case. That's just how, in my experience, talking with women about having children in the home, and sometimes how kids can even turn on them as mothers because they take on the thinking of the father. That's how I explain it. And the prosecutor knew from the other facts of the case that actually was what the mother was going to testify to, and it fit the case. So that's that's how that piece would play out, so that I can maintain that I really don't know the facts of the case, and she's just inquiring of me, if a woman was in this circumstance, how would you explain that? And then she decides whether my explanation fits or not. And then the piece about providing context for understanding how the batterer thinks. Because I work with both Melissa and I both work with men who batter in men's group, we're in constant conversation with them about what they do, how they gain control, what they think what do they believe that drives that. And there's a way to talk about what she's experiencing by first talking about what he does. So for example, if it's coercion and threats, for example, the woman may, a woman who's battered has basically three choices. She can fight him, she can leave, or she can submit. And a woman who's being battered tends to do one of those three things at many different times during the relationship. So it doesn't look consistent to the jury. And so how do you make that that makes sense to put that in context? And so coercion and threats, to understand that the violence that he's done, whether it's putting a hole in the wall, whether it's the physical violence that he's committed against her in the past, whether it's the violence that she's seen him commit against other people, something that he's done that lets her know that he can absolutely go there. And then when he makes the threat, that violence stands right next to him. It never leaves his side. And it's always omnipresent for her when he's telling her what to do. when he's saying, if you don't do this, this is what's going to happen, kind of thing. And so that they can understand what world she stands in when he's asking for or telling her what to do, so that they can better understand why she decides to make the choices that fit that particular case.
So the next piece we're going to talk about here a little bit is we're going to talk about what to consider when you're thinking about becoming an expert witness. So one of the things that we learned early on is that, and we just made a decision about and have not done, is that we don't testify in one's own community. And so what that means essentially is when I started doing this work, I just worked in just Itasca County and was not working in St. Louis County. However, the work that I do in St. Louis County is I do administrative work, and I do program evaluation work, and I do national training, international training at domestic abuse intervention programs at Duluth. So Scott and I have worked it out that we don't testify in cases in which we do local work, meaning that Scott does local work in Duluth, and I was doing it in northern St. Louis County and in Itasca. And so we've essentially swapped those communities. So if there's expert witness testimony to be had in Duluth, for example, I'll do that, and Scott will do it in our own communities, because inherently you're just going to end up knowing too much about what's going on, about the case. And so that's part of the reason why we don't do that. Another piece of that is that, which we can talk a little bit more later if people are interested in knowing, is that, you know, we do this outside of our jobs, meaning that when I started this, I had to talk to our board of directors to see, you know, was this work related, is this not work related? And so what we did is we did, you know, sort of a missions test, meaning that we looked at the mission of the organization and said, does this activity or you know, of myself, does it fit that? And what we decided was no. And so what we said then was that I would do it outside of the community. I would use my vacation time or personal time, and that the agency would not be charged for any of that time and funded because it didn't fit within that. And so that was another piece of it for me and for Scott as well. So we do it outside of our jobs, as you know, in the domestic violence programs. The next piece then is that do you have a curriculum vitae? So curriculum vitae, you know, I'm sure that there's some, I don't know, webinar out there about how to make one. We've kind of created, you know, I've looked at a few of them, but we kind of created our own format, and we're happy to share ours so people can see what they look like. But essentially, that was a major task when we started to do this. So essentially what we did is that we listed every single training we conducted, or at least tried to. We ended up finding out that we had missed a couple, and Scott has a little bit of a story about someone a defense attorney who caught that, one that he didn't list. And so it is a big task and undertaking to do that. We made a decision to not list all of the trainings we've attended as a participant, because that would just be extraordinarily long. We have a challenge in and of itself just keeping up with adding the ones that we've been the trainers on. In fact, doing this right now reminds me I need to add a couple more to mine. So the way that we've organized it is we've organized by articles that we've been the primary author on, a secondary author, or we've done reviews or edits on. So sometimes we get listed in publishings as a person who reviewed. For example, it was then the Family Violence Prevention Fund. It's now Futures Without Violence. But you know, early on, I got asked to review a number of documents that were written, and so those things you add. So anything that's written or in writing, any curricula you might have been a part of authoring, co-authoring, or been a part of creating. Every training you've done, the subject areas in which you've done them, a list. I've included a list of communities, a sampling list of communities in which I've done, and then any sort of like roundtables. Maybe you get asked to participate in a roundtable. I've done them for the Office on Violence Against Women. I've done a number of them for UN Women, and so to list those as well. So it's a big undertaking to organize all of that. And then the same goes with your resume. I mean, for people early on in their career, like I know a few people who might have embellished a bit on their resume. This is not the time to do that at all. I mean, I've looked over that. In fact, anytime I hand over that document, I look and re-look just to make sure it's accurate, because, your credibility is extraordinarily important when it comes to this, so you want to make sure that it's accurate. So I wanted to make sure that was accurate going forward.
Yeah, so just to follow up with what Melissa was saying about, Melissa, myself, and a prosecutor from Stearns County had done a 1-hour workshop for our state Office on Justice programs, and it was kind of a little one-off thing, and I did not put it down on my CV. Well, it just happened to be on testifying as an expert witness. So the defense attorney from Minneapolis finds it and holds it up and suggests that I purposely kept it off because I don't want anybody to know how I manipulate juries, which is what I was trying. You kind of led it down that road. Well, so in the end, it didn't. It was just a bunch of smoke. But if you're like me at all, you want a tight ship. You don't want anything out of place. The same thing with my resume. I mean, I've testified almost 30 times, and I've never had anybody ask about my early retail career. I had one attorney say I wanted to go over my retail career, and I worked for Dayton Hudson Corporation as a sales manager. I didn't remember the dates. I just had to kind of go with what he said. So then I learned I got to remember everything on my resume. In Minnesota and in most states that I've worked in CCR with CCR teams, the prosecution is required to send the defense some document, and it's called different things in different places, but a document that gives the defense some idea of what you're going to testify to. Now, it isn't what you're going to testify to in that particular trial, but in general, what your testimony, the approach, the context, what it sounds like, and there's a piece that Melissa and I are going to publish through the clearinghouse, and it's going to have an example of what that looks like attached to it. So you'll see what it is, and it's basically 2 pages. And the same thing when I testified in federal military court. They needed some idea of what I was going to testify to, and that document fulfilled that request. So you'll need to put something together about the context of battering, some of the counterintuitive decisions that women who are battered will make, and in what context. So the research piece is an interesting one. I mean, when I first started doing this, I thought that's kind of, you see it on TV and everybody's quoting research, and that you think that's the way it goes in the courthouse, and it does for some topics, but for this, prosecutors really don't want you to rely on research. If you can talk about the context, the counterintuitive decisions without any research, life's good. There was a particular case that I testified in where recanting was and I don't remember the context, but it was a much bigger issue that had to be dealt with. And there was a piece of research that I used on tracking how offenders were able to get victims to recant and come around to a different kind of story about what happened, that I used it as a backdrop to my testimony. So my experience talking to women who were battered told me about how they came to recant, why they decided to call the prosecutor and say, no, this never happened, and I fell down the stairs or whatever the case may be. That's what the prosecutor wanted, but she also wanted me to back it up with some research. So I didn't rely on the research. It wasn't the mainstay of my testimony. It was just it backed it up. And that's the extent of which, no matter where I've testified, that's what the prosecutors would prefer, because there's a lot of complication that gets into your testimony when you rely primarily on research that you don't have any experience to back up. So just think about that when you use it a lot less than you might think in these cases. And then one of the things that I think, as a trainer or as somebody, who's a witness who's got a complex circumstance that they're trying to communicate, there's a lot of moving parts in how she's navigating the threat that he poses. And if there's ways, if there's edited examples that you can give to help people understand what it looks like when you're up against that particular circumstance. So I was testifying in a case where the victim had a 17-year-old boy, and in that location, she could not bring that child with her out of the home to the shelter. And so she ended, again, I didn't know this, but I know of women who have stayed longer in those relationships than the rest of us think that she should, because she couldn't take all her children and get out, or she couldn't figure out a way to get out and stay out with an older male son with her. And so when I gave that testimony, there was actually a gasp from the jury pool. And later, when I spoke to the victim witness person on the case, I asked if they had polled the jury, and they said they did. And I asked if they knew what that gasp was about. And she said that the woman on the jury pool, that was the first time she understood why her mother had made a decision that she did. So it really, it's again, it's not fact specific to the case that they're making a decision on, but in general, it gives an idea of what women in general are up against when they're, in this case, trying to get out of that house when they have multiple kids or kids who they can't bring to shelter. So those edited stories are really helpful.
So, Cindine, it's Melissa. So we'll take some of those questions now. I think now is a good time. So we'd like to do this about, every half hour or so. So I've seen them, but do you want to just ask them, and then Scott and I can decide who will answer?
Sure. We got one question from Peggy about whether experts are required to answer personal questions about them when they're on the stand, and if there's any limits to that.
Yeah, so we can be asked personal questions. I would say that my experience has been, though, that it's been quite limited in my experience. I do remember a time where I was asked if I was a victim of domestic violence myself. I remember that becoming a question. So, of course, that can be deemed as personal. But I don't remember, I haven't had an experience where I felt like it was like somebody found something, I don't know. I haven't been arrested before. So, but if I had, I'm sure they'd know. But, we have all done things that, I'm sure that we wouldn't want others to know. But I haven't had any of that sort of experience. But, I always feel like, for the most part, the judges have all been pretty good about, relevance of things. But I do know that when you are an expert witness, that it's about your credibility. So, yes, of course, it could happen. But I haven't had it happen. I will say, though, I am running for a political office for the first time in my life. So now I'm expecting that, there's some decision I might make that at some point could probably become used, because I'm planning on winning. But, but so far, no. But the answer is yes, you are subject to it. Scott?
Yeah, the only time it was really not much of a a personal question as much as it was. I had a defense attorney in a federal case where he said, I met Mr. Miller before the hearing. Seems like a nice guy, but that's about it. A way to dismiss me to the jury, to the court. And that's just he's doing what he does. He's advocating for his client. That's what he does. I don't take it personally. They'd like me to, I suppose, because it would reduce my credibility. But I understand what his role is, and he's doing the best for his client. And I'm a neutral person who is just testifying to what I know. And everybody's going to do their job, and I'm not going to get involved emotionally in the decisions that other people are going to make. So
I see there's a bunch of questions, but I want to stay with this follow-up question. If the lawyer were to learn that the expert was a domestic violence victim or not, is there a way that you think they could use that against you?
It's Melissa speaking. So, the answer for me was yes, and I have talked about it publicly, but, my experience was as a older teen. I was between the ages of 16 and 18 when I experienced violence. So I'm imagining they could. I'm just kind of thinking out loud here. My guess is, it would probably be some bias sort of thing. I'm not really, would be my guess, that's kind of all I see, is violent relationships. But, I think it would be probably, like, for example, I know a woman who's been battered who I think has a lot of potential to be an expert witness. However, she also ended up getting arrested and convicted for a time when she used violence against him. So there are a lot of things that could end up in police reports. I reported mine, but I was a juvenile, so it's a sealed record. So, if there's a record of it and there's a statement, the thing is about this, you have to just assume that whatever you've said or done that's a public record, someone will try and use against you, right? So, for example, Scott and I are social media, check-ins with each other where I'll be like, you might want to rethink that post you did, or he'll say that to me, right? Because in part, everything we do is subject to it. And I would say, so it's the attorneys, the well-resourced defendants, or in family court, the well-resourced men who batter, who have like 5 or 6 paralegals. It's the paralegals who are going to find it. And then the attorney is going to decide how they're going to use it. So anything that's a public record of you is subject to any of that.
Thank you.
I would just want to add one thing about that. I interviewed a defense attorney about what their goals would be going after an expert witness. And they said, and this might be her particular attack, but she said, if I want to make you into an advocate, as Melissa said, I want to have you show bias, that you're not just a neutral person who's testifying about what you know, but you have an axe to grind. And if I can do that, then I can reduce your credibility. And so, the position that you are in that environment that I talked about at the very beginning, the only 2 advocates in that room are the attorneys. Nobody else is. Okay? So when I may be an advocate in your work, but when you're in that room, you're simply testifying to what you know. You don't have an axe to grind. You're not trying to get the person convicted or exonerated. It's simply testifying to what you know and being neutral in your presentation. So that's really the liability is if they can demonstrate or get you to demonstrate that you have a bias, and you shouldn't. I mean, if you do, then this isn't probably your work.
Thanks, Scott. And to kind of stay in this area around, the questions that you were asking your defense attorney colleague to get you prepared to go on the stand, can you talk about what those terrible questions you got from your prosecutor friend and your defense attorney friend were? Like, you said that they grilled you and that you told them to do their worst. So what kinds of tough things did they ask you, and how did you respond, or how did your response develop over time?
Well, the length of my answers got brutally taken apart.
Okay.
I really, because as a trainer, right, that's my venue, is that I'm gonna take a complex thing, I'm gonna explain it to an audience, right? That's what I'm gonna do, and that's not going to be allowed in that. I mean, the defense is just not going to let me go on and on and on. So I had to find a way to really discipline myself and think through, how do I want to edit this explanation down to a appropriate amount of time. That was a big one. Another one was when they ask an obvious question. My tendency in that meeting was I didn't want to answer it. So, for example, is it possible that a woman could call 911, lie to the police about what happened, and then later recant it, not because she is scared, but because simply she understood that she was lying and felt bad about what she'd done? Now, I know where this is going. I can see what the attorney is trying to lay the foundation for, and there's a part, when I was in that meeting, there's a part of me that says, no, I'm not going to, I just wanted to argue with it. I have to say yes. It is possible that somebody could do that, right? And I didn't want to have to answer that because I knew where it was going. But that now all of a sudden I'm in an antagonistic relationship with that attorney, which goes to my credibility. And so, I actually had that question asked of me in open court once. I had a few variations of that. And my answer now is simply, yes, it's possible. I've never experienced that in my work, but yes, it is possible, right? As opposed to trying to fight with it like I know what you're, and not answer the question, yes or no. So those are two things that I'm glad that I vetted out in a meeting room as opposed to open court.
Melissa, is there anything you wanted to add about tough questions or lessons learned like that?
Yeah, I would say the thing about the long answers, giving the long answers. I remember at one point that, the prosecutor thought we'd kind of test it to see how long the judge or defense attorney would let me go, because part of it is that it's a little bit of a balancing act between there's things you want to tell the jury, but the prosecutor might not be asking the right question. And so one time I gave an answer to the question, and then I weaved it into another topic and started talking, and it took a while for the defense to figure it out, but yeah, so length. And I also just think you have to be able to read the jury a bit in their body language. Like, are you losing people? I mean, it's the same way in which, you're training, because there is a thing about succinctness and clarity that has to happen.
Yeah, and it's actually a really good discipline, because to Melissa's point, you're not talking to people in the field, right? You're talking to people who are coming, the general public, and the clearer you are, the more succinct you are, the more grounded your answers are, the easier they're going to be understood. And then the jury gets to decide if they're helpful or not.
Thank you. Do we have time for a couple more, do you think, or do you want to move
go
on
ahead.
for now? Okay. We had a question about your fee schedules, if in fact you charge for your work, and if so, if you're willing to talk about how much you charge, and I guess the kind of activities that you charge for would be helpful to know too, whether it's preparation or court time, and whether those are different.
Sure. So Scott and I made a decision to do this together, for consistency in the state of Minnesota, and so it was interesting because we we didn't really know what we should charge apart. So, and I'm going to tie this into the question, about how our board came to make a decision about it not fitting our mission, because I saw that one also.
Great.
Part of it was that because, we looked at our agency's bylaws and mission, and because we made a decision to not do it in our own community, then we weren't serving our own community. And so that's why it didn't fit the agency and the mission. And then also there's this thing about payment that was happening. And so it was about who would get the money, and there's issues about being, duly paid for things with certain funders, taking in money. And so the board really looked closely at the bylaws and mission and said that, the area in which you would be serving doesn't fit the geographic area, first of all, and it's not something that is tied closely to our mission. It would be something that we'd work with locally in our community to have happen, but that, I wouldn't do it. So then the thing about the fee, so we kind of went back and forth, and we've stayed at the same amount now for quite a few years. And so what we've known, so, in Minnesota, there's a lot of single lane roads. And so a lot of the places just take a really long time to get to. Like the one we go to the most takes us, anywhere from 3 to 4 hours on single lane roads. So we're charging for travel time, so the time it takes for us to get from our destination to the courthouse. So for that, we charge $55 per hour. Or is that $45 per hour. And then the court time is what we call it. That's $90 per hour, and that is what we call court time is prep time with the prosecutor, courthouse waiting time, and actual testimony time. Now, the second one we added because what we realized after time is sometimes I've spent more time waiting in the hallway to testify than actually testifying. And so I'll do a lot of prep during that time, but that's kind of how we've distinguished it. And so then, of course, I want you to know that that's generally, for myself, and I'll let Scott speak, but that's the most I've testified. I have done it, for less than that, and it just kind of depends on the community. I will tell you it's a very interesting discussion to have, because in some communities they've laughed in their response, and they've laughed on both ends. They've laughed at that, oh my gosh, you're the cheapest expert we've ever had, and others have laughed and said, oh my gosh, we'll never be able to afford it. And so part of it is a little bit of a balancing act, I have to tell you, and the reason about the amount for us in Minnesota is because there is a credibility thing, interestingly enough, that happens with how much you're being paid. So if you charge too little, then people think, well, you're no good. And then there's sort of this notion that comes with that. And then you also don't want to charge too much. And so I have a family member who works in the medical field, and he was talking to us about, like, for example, when medical providers testify. In Minnesota, the minimum amount is usually going to be $200 or $300 an hour for that. So, and most of the other experts usually come in that regard, and that's what they're charging for their expert time. But generally, that's what it is. I would say, when people say, well, what's kind of an estimate? It could be anywhere from $300 to $1,200, depending on the case, the time, and the distance.
Yeah, and I would say that in family court cases, it's a little bit more because now I'm going to know about the facts of the case. I'm going to read the guardian ad litem report. I'm going to read a psych eval. I'm going to read a lot of documents. So that's all $90 an hour prep time. And so I would give the attorney or the prosecutor a general idea about an approximation about how much is this going to cost. Now, as Melissa said, I've gone someplace and I've sat the entire day and never testified. Well, I'm taking vacation time from my job to go up there, so that's why we're going to get compensated for that time sitting in the courthouse. And the thing about the other one aspect about the mission that I would want to mention too is that if you're on the stand and you're testifying and you're working for the agency and you're an advocacy agency, I mean, it's a fair question. Are you doing your agency's mission right now? Are you being the advocate that your agency, the purpose area that your agency serves in this community? And that's a fair question, right? So we really believe that as expert witnesses, we needed to completely separate ourselves from the agencies we work for, not only because it didn't actually fit the mission, but we didn't also wanted to be able to say, no, I'm a neutral person. I do this job. I've learned a lot of things doing it, and I'm here to testify as an independent expert witness that without bias in this particular case, and that made it a lot cleaner to do it that way. So,
thank you. And one more question before we kind of move on with the rest of your presentation. We got a question about whether or not you are contacted by the prosecutor or whoever is using you to testify before subpoenaing you, and whether or not you receive questions in advance.
We don't typically receive questions in advance because they don't even, most of them don't know what we know, so they need to interview us to find out. So I've actually sat through on a federal case, I think the interview about what I knew was 2 hours long just to figure out the breadth of what I knew. They knew the facts of the case, and they were just seeing, is my experience in this work able to be an asset to their case. So, yeah, that comes before the subpoena. That comes before the questions, is, figuring that piece out. Now, the attorneys that have used this a number of times, they know what we know. So they'll typically call and ask for if we're available on a particular date. So, July 15th, are you available that day? I'm going to need an expert. Yes, I am. And then usually what will happen is that the prosecutor will wait until a few days, sometimes the night before we're to testify, because the individual could take the plea. I've actually driven all the way to a courthouse, 3.5 hours, got there, sat there, was waiting to testify, and then the guy took the plea, and I went home. So they don't want to waste time and money on us unless they know that they're going to use us. So a lot of that happens right before the case, typically.
Thank you.
This is Melissa. Yeah, I just reiterate that the prosecutors are going to want to talk to you a lot, but we've just found that, so many of the cases we get subpoenas for, we get many more subpoenas than we actually testify. I don't even know what the percentage is, but we get a lot of subpoenas.
I bet you I get 4 subpoenas a month, and I might testify once every 3.
Wow.
Yeah, the same is for me. We get numerous per month. We get a number of calls per month, and so it would be about the same. But we end up testifying we actually testify about 3 to 4 times a year would be a good average number, but lots of subpoenas. So we don't want to charge the prosecutors that time. In the same cases, I'm a lot of times saying, do I need to get in the car? I want you to call me, have your victim witness person call me to say, yes, get in the car, it's going to happen, because so many times it just doesn't. Please come at the last moment.
Yeah, and I just had a case, an attorney called me on a civil case, custody case, and she said, I've got a hearing coming up, and I'm not sure, I want to retain you. And I said, you know what, why don't you have that initial hearing first to see if it's going to go somewhere, if it's going to go to trial, before you bring me in, and then if that's where it's going to look like it's going to go, then give me a call and we'll prepare. So.
But the one thing I want to add to that, though, the one thing we found out anecdotally, and I'm interested in finding a prosecutor who's willing to sort of organize it in a way to sort of get the data, is that anecdotally the prosecutors, we've agreed for them to put us on the witness list, and a number of prosecutors have said to us that they have gotten a level of plea that they have never gotten before just because of the sort of idea, the presence of an expert witness. So, for example, prosecutor in Stearns County recently said to me, she said, I have never gotten a plea on a strangulation. It's almost always been reduced. And she said, I really believe it's just the fact that I said, I have an expert, she's available, here's her credentials, you need to know that. So I never got a subpoena. She knew that I was potentially available. And she said, I can't tell you what that discussion was, and why they decided to plead, straight up to a strangulation. But she said, I can tell you that's never happened before until I added an expert witness on the witness list.
Yeah. So so the reason that works is because they've actually used expert witnesses successfully. If the jurisdiction never goes to trial, of course the defense bar understands that they never go to trial, and you're not going to get the same kind of plea agreements. I had an attorney call me from a place in southern Minnesota and said to me, we've been taking them to trial, but we haven't been winning. So we'd like to try an expert witness. And again, I don't know what happened there, but that individual ended up taking the plea as opposed to going to trial. So, from the feedback that we've gotten, it's helpful in negotiations with prosecutors when they know they're going to go up against or have this as a resource for the case.
Thank you. It looks like for now, anyway, that's all the questions that we have. So if you both want to move forward, now's a great time.
Okay. So so one of the things you're going to be asked about is how many times a month, a week, a year do you talk to women who are battered? How many times do you engage with men who batter? Those are going to be questions that you're going to ask because it's going to, it's a legitimate question. How much experience do you have talking about what you're going to be asked about in this court? So this is something you're going to want to think about, because I know, like, as advocates, you go to court for order for protections. You do individual advocacy, or you're doing systems advocacy, and you're doing focus groups. Think of all the different ways in which you come in contact with either victims or offenders in the work that you do, and you have some way of talking about that. There's a way that the defense will want to characterize their client as not a batterer. Now, my expertise is in battering, so a relationship of battering. That's what I know, and they'll want to try to get me to talk about sometimes relationships outside of that. And like, here's an example. Could it just be that somebody isn't really good at relationships, but they're not really a batterer because she's not really scared and he's not really trying to get her to do something, and that may all be correct. But what I'll remind the attorney is that my expertise is in relationships of battering. It's not in relationships in general. So I'm not going to make a comment. I'm not going to go in that direction. So you really need to have an understanding of what you're talking about. And then if there's somebody battering, there's going to be some level of resistive behavior on the victim. Sometimes that's violence. Sometimes it's illegal violence. Sometimes that's what the general public would look at as bad behavior. But you're going to need to be able to place that for the women that you've talked to about, so what is that about for her? Why would she do that, given what she's experiencing with somebody who's trying to dominate her? So in a relationship of battering, there's words that you want to be grounded. He's trying to dominate her. He wants her to submit to what he wants her to do, and she resists his attempts to submit by And then really being able to talk about, well, is every time somebody gets hit battering? Well, no. In a case where there's no fear and there's no violence and there's no coercion in that relationship, but one of the partners decides to step outside the relationship and commit an act of infidelity, and the other partner finds out about it, and he comes home and she confronts him and he denies it and she slaps him across the face. That's the crime of domestic violence, but it's not battering. Battering is with the intent to dominate the other person, to get them to submit to the will of the other person. That's a different thing. So being able to articulate all those differences so that the jury can understand those three different ways of using violence, but also being able to respond to the defense questions where they want to lead you in the direction of a non-battering kinds of relationship.
So the other thing that we want to make sure that you have is, experience in training and doing formal trainings, because, this is similar to doing a training or a presentation in the sense, that you're a person who doesn't stumble with their words easily. You don't get nervous very easily when you speak to a group. And so those sorts of things you want to kind of be thinking about, because formal training experience will prepare you for this, because also, when you do a lot of formal training or presentation, you get, challenging questions, difficult questions, that happens. So that experience will help you in this regard. The other thing is that you want to make sure you have a good understanding of court processes and that you know what's happening when it happens. So, if somebody makes an objection, that you need to stop speaking, for example, or that who all the players are in the courtroom. So if you're a person who thinks you might be well positioned to do this, we would say spend a lot of time in criminal court. For sure, go and observe a full jury trial even from the beginning where they're picking the jury. Understand what that process, what the rules are about that in your state. So you have some idea of who's sitting there and how they got picked, and who gets to pick who the jurors are and who gets to strike who potential jurors are. So you want to make sure that you really, really have a good understanding of that. And then if you've ever published or been part of research or reviewed research papers for, a federal or a state agency, you want to make sure that gets emphasized when you're making the decision to go forward to do this. So the next, sorry, Scott took off his mute there. So the next thing is we want to know a little bit about is what you want to know about the case before it happens. So what we've gone back and forth about this, and Scott will talk about this a little bit, but generally what we ask is we want to know about the relationship of the partner. So for example, our expertise is in intimate partner, heterosexual domestic violence relationships. I do not have expertise in same-sex relationships. I do not have expertise in, college roommate versus college roommate, which could be a domestic assault, or, necessarily brother-sister. So it's one of the first questions I always ask. What is the gender of the offender? What's the gender of the victim? And then the last thing is the purpose and the need for the testimony. What is the gap generally that the prosecutor is trying to help the jury better understand? So as part of the testimony that we would provide, there's a lot of different things that Scott and I provide testimony about based on our experience. So, for example, at Advocates for Family Peace, and one of the domestic violence programs I work at, we do housing. We do emergency housing and we do transitional housing. So I have a lot of experience in that regard. So, for example, we had a battered woman who the transitional housing was being all paid for and provided for. And so, this happens when you do this sort of work, that in the middle of the night, one night, her and her two kids, she up and left, took everything and was gone. And, we had some idea where she had went. And so, that's a particular experience I have where, Scott doesn't have that experience because he hasn't worked with women who are living in an agency's housing. And so there's the purpose and need, and then the context of the victim's life, because the reality is that we're not all positioned to talk about every instance of domestic violence. And so you want to know a little bit about that. Now, Scott's going to talk a little bit about the case-specific stuff, because we have gone back and forth about how much to know and how much not to know. You should find out in your state if there's any rules about this. But generally, our experience has been there's a difference between providing expert witness testimony on the issue of domestic violence and its effects or battering and its effects versus providing an expert opinion about the facts of a particular case. And so, we're not interviewing anyone who's in it. We don't know the people who are the defendants or the witnesses, and so it's a very different sort of testimony.
And I think part of the confusion out there is that there's confusion by the bench. There's been a lot of varying decisions that have been made in different cases. In criminal matters at the state level, typically the strategy is from the prosecutor, I don't want you to know anything about this. I want to ask you questions, and the credibility of your answers and how they link to the facts of the case are going to be that you don't know the facts of the case yet. What you're talking about as far as who men are, who batter, and who victims are, who experience this fit exactly what this case is. Here's an example, quick. I don't know that they've got film of this guy getting arrested, calling her a cunt and a whore and a bitch. And when I was asked the question about emotional abuse off the power and control wheel, I said, well, the 16 years I've been doing this work reading police reports, I can't think of a time when I've read one where he's referred to his partner by her name. She's things like she's a cunt, she's a whore, and she's a bitch. Well, then, the jury's already seen the videotape of the arrest, and they know that I don't know any facts of the case. So you see where the power of that can be, because there's a lot of things about men who batter that are very similar, regardless of how they learned their bias. They behave very similarly based on the power and control wheel, which is a very helpful tool in court. Now, in federal court, it was interesting because the judge didn't, it was okay that I knew I read every document that the prosecution had. I knew everything about this case, and I was acting as a consultant to the prosecution for the whole week's trial. And I testified as an expert witness, but when I testified, I was directed to not testify to the facts of the case, but to give general testimony, even though I knew the facts of the case. So that was fascinating to me. In family court, there's even more diversity. I've been told that I shouldn't know any facts of the case like criminal court by the judge, or if I do, I can only testify in general. I can't testify and give opinions on the facts. Another judge allowed me to listen to testimony from the victim, which I thought was interesting, and then allowed me to testify again and actually answer questions about the facts that were testified to by the victim. So I think that there is a lot of inconsistency on behalf of the court because this is a new thing and people don't quite know. I think if this is more routine, obviously there'd be a more routine way that this plays out. And there's a lot of variation. And I'm guessing that would be the same in most people's states too if you started doing this.
So we're running out of time a little bit here, so just going to go through a couple of these things here quickly so we can take a few more questions if there are some. So if there are some, if you want to post those, that'd be great. But a few things about, laying the foundation. And so this is, with the prosecutor and when testifying. I've talked a little bit about this already, but, you want to have your job description. That's one of the things that comes up when I just talked about earlier about, what's the gap you're trying to fill, and what's your work been in the field as it relates to domestic violence. As I said, I've done years of advocacy, directly with battered women, directly with children, and so, that, and then what was my job been in the field previously, what's my job now? That's something for the prosecutor to understand. What kind of trainings have you conducted? Has there been an emphasis in one area or another? For example, I did my doctoral dissertation research proposal on something related to supervised visitation. So there was a period of time where, a lot of my CV had a lot of supervised visitation. And I remember a defense attorney at one point saying, well, you don't really know, you know a lot about the supervised visitation thing, it appears, but, not much about domestic violence. And so, there's all these ways in which that stuff can be characterized quite a bit. And then, like I said, the areas of expertise and linking those to victims' experiences. So, for example, Scott and I have both done men's groups, work in groups with men who batter, but our organization in Duluth, and the Duluth model, heavily links our work in those men's groups to the experiences of women and holds as primary the safety of battered women and their children. And so we can easily link that. But, if you're doing Battered intervention program work and that's not as much the case as maybe you'd like it to be, you want to make sure that you're going to find a way to talk about, if most of your work is with men who batter, though, how you're linked to the experience of victims who are battered.
And I'm just going to talk about that last bullet there. The other two are self-explanatory. But if, when I got a call, I actually got a call from an attorney one time who said, all I want, your testimony is going to take like 5 minutes. I said, well, what are you going to have me testify to? I just need you to get up on the stand and say that in your experience, do most victims recant? You say yes, and you're done. Well, I'm not an attorney. I'm not a prosecutor. I'm not trying to tell you how to do your case. But for the prosecutors that are experienced using expert witnesses, they have a whole different strategy around using the testimony. So there, I've had attorneys on the continuum from say to me, okay, teach me, how have you been used? Tell me what the strategies are. Who are the prosecutors that I should contact to find out what the motions and that I should submit, and all of I want to learn to. Let me tell you what I'm going to use you for, even though I can tell that they've never done this before. So it's just one of those conversations where I don't want to, you're up as an expert witness, you're on that stand, right? And you are at the mercy of the person who's asking you questions. And you're only going to be as good as the questions you're asked. And so, any time that I felt like what I know has gotten it out to the courtroom for in this particular case, the judge to make a decision, it was because the questions that the attorney that was asking in that civil case were so good that they got my testimony out. I've had other attorneys say to me, so, what about your CV would you like to talk about? Well, what's your question? I can't just start talking. I have to have a question, otherwise I can't answer. So all of that kind of stuff really needs to be exchanged at the front end between you and the attorney. And Melissa and I always send that booklet that's, again, that monograph that we have listed at the end of the PowerPoint to the attorney and say, read this. This is how I approach this work. And if you know this, then we can start communicating about how to use me. And that seems to really help, and it's appreciated by most of the attorneys we send it to.
So I just want to say, a lot of these questions we've already answered, so I just want to open it up to questions that people might have.
Okay. We have a few. When have you or Scott ever been asked to testify in a case for the prosecution when the defendant is a woman?
Yeah, this is Melissa. So I have. In fact, I have a few times, in part because I have done work in groups with women who have been arrested in Itasca County and in St. Louis County, and then I'm one of the co-authors on Turning Points a nonviolence curriculum for women, which is a group curricula for working with battered women who've been arrested. So I've been called a number of times, but actually haven't testified. All of those cases have resulted in a plea. And so the most recent one was a murder case, actually, in the state of Minnesota. The thing I want to also just mention about that, it was a higher profile case, and we haven't mentioned this, but Scott and I both have been asked to testify in high profile cases. You need to be aware whether that's the case or not. In this case, I did not end up testifying, but the media got a list of all the persons who were set to testify. So the media did contact me after that, and I did not return their call. You're not obligated to return the call. It's your own decision whether you do or not in those. But I've made a decision personally to not speak to the media about high-profile cases. So you should just kind of expect that. But there will be a number of cases. There's been a few cases also of professional athletes where we've been asked to testify. And so it turned out we did not have to end up testifying in those cases. But yes, I've been called by the defense when it was been a battered woman. I'm not sure if Scott has, but I have a few times.
But have you been called by the prosecution when the defendant's been a woman?
Sorry. Oh, I have not. No,
okay.
I have not been called by but I will say this, though, that it's an interesting question, though, for you to ask me, because here's the thing, is that, people have asked this question of me a number of times before. The reality is that, because we're speaking about what we know about the issue, honestly, I don't know. I mean, I know it'd probably have a little bit difference in it, but it wouldn't be that much different because we're talking about the issue, right? Because we're not doing a review and providing expert opinions about the case. And in that sort of case, the defense attorneys are motivated to have me, be there. But if a prosecutor did, it wouldn't be that much different.
Yeah, we know what we know. And so we're not, the only way that our testimony is geared towards one side or the other is just by the questions we're being asked about what we know. So I may know, a shipload of information, but I'm only going to be asked about a fishing boat load of it, right? So, but it's still not going to change based on who's asking me the question, right? Because we're given neutral, general testimony about the dynamics of our battering relationships.
One of the things on this slide that I have up, I just want to make sure we get in quick before we get off, is that how we define what we testify about, that we do not testify about battered women's syndrome. In fact, I know I've had one case or a couple cases one in particular I remember going to Court of Appeals. It was an unpublished opinion, but one of the things that the defense attorney was saying was that my testimony should not generally be used, and saying that I was testifying about battered women's syndrome, and I was not testifying about battered women's syndrome. In fact, it was one of those times where you have to be very careful to listen to what the defense questions are, because I knew that the defense attorney was trying to get me to call it that. In fact, if my memory serves me correctly, he said something to the effect of, battered women's syndrome is this, right? Or something in that regard. I said, I'm not here to testify about battered women's syndrome. And so I knew that he was trying to get me to say that, so something could be held up on appeal. So I just want to say, we did call it counterintuitive victim behavior, and then that had lots of confusion about how it was called. And then we either call it domestic violence and its effects or battering and its effects. But I just want to say that, you will likely, if you do this, have a case go to the Court of Appeals and have your testimony in part be part of the reason for the appeal at some point.
Yeah, 3 of our cases have gone to the Court of Appeals.
Do you want more questions, or do you want to keep moving forward? I see that we have about 6 minutes left. Scott and Melissa, are you still there?
Sorry, I was on mute. I'm sorry.
Oh, okay.
Okay. So one of the things that you want to, if you can, like if you have a local college that teaches law enforcement, there's probably somebody coming in to teach them about how to testify. And see if you can take that class and just kind of sit in and listen to what they talk about. There's a whole lot of things, again, that really helped me before I testified understand, again, the environment I'm walking into. So one of the things that I do is that when I park my vehicle and I get out of it, I am now in that mode of how I'm going to testify. If I see people that I know, I don't joke around with them. I politely say hi. I don't have chit-chat conversations that can be overheard by other people in the hallway because I don't know who's a juror. I don't know who is a witness in this case, and I don't want to look like I don't do anything that would reduce my credibility. You go to the restroom. There's jurors in the restroom. One of them said hi to me. I said hi back and immediately excused myself out of the room because I do not want to be in a conversation with a juror. But they all wear badges, so that helps. When you take the oath, it's really an important duty that the jurors feel that they are engaged in. And if you walk up and you take this kind of haphazard oath, like you're not at attention, it doesn't look like you're taking it seriously, then they might not take you seriously. So there's just a lot of stuff about just generally testifying as a witness in a criminal trial that can really be helped by taking one of those classes on that help law enforcement officers testify in open court. So if there's anything you can do in that regard, that would be really helpful too, to throw that in. Any questions?
Melissa talked in the beginning, in your introductory piece, about how in certain communities, kind of the practice of having expert testimony, or at least putting you on the witness list, has become kind of an institutional practice. And I'm just wondering, do you see any downsides to that?
We're not hearing anything from the prosecutors. I mean, they've made it it's what they do on every case. They just, I'm trying to think of if I've heard anything.
This is Melissa. We haven't. I will say there has been a couple times when I have testified as an expert witness, and my guess is that the victim has already testified and is in the courtroom and listening while I've been testifying. And so I can't confirm this to be, fact, and I won't. But, there's been a couple times when I've testified where, a woman has gotten up and walked out and seemed to have an emotional response. And so, it's always, I'm not going to speculate what that's about, but that can be, hard. I will say that, there was a time where Praxis International had gotten together when they were doing some early criminal justice work. They were able to get together some women whose partners had been prosecuted, and when they had been prosecuted, basically they had been at least, I believe, I'd have to ask them, but I believe it was at least 5 years out from the prosecution, and their partners were convicted. And the question posed to them was, generally at the time, all of you were unsupportive of your partner being prosecuted. And so where are you at about that today? And interestingly enough, because this is a question for me, as a person who's done a lot of advocacy, when I'm providing expert witness testimony, I have to ask myself, am I working towards the safety of battered women or against it, right? It's the question we get asked often. And interesting that I learned from that focus group or interviews that Praxis had done was that overwhelmingly the battered women said something like this. They said, here's the thing. At the time, he promised me the world. He said, if I don't support this, if I don't testify, He will stop drinking. He will be kind. He'll help more with the kids. He'll do all those things. And overwhelmingly, the women said, guess what? None of that happened. So the fact that you held strong with him and he has this conviction, it means a lot to me because it validates my experience then. Now, I wasn't in that place and at that time then, but I'm glad that you were. And so it was a real interesting sort of learning and reflection. So I'm actually curious to try and do that, to get together some women whose partners had been prosecuted, a number of years out and hear from another group of women again. So I know we're at the end of our time. So any last thoughts?
That's what I was just going to ask you and Scott, actually, if you have any closing words of wisdom.
No, I would just say that, just feel free to contact us. We're happy to talk to people. I have the slide up about the monograph, so make sure you take a look at that. That paper is forthcoming, but we're happy to talk with people about it.
And I would say that, if you're thinking about doing this, if you go through a lot of the steps of preparation, that will reduce your anxiety because, sitting up in front of on a witness chair is an anxiety-producing event. But understand that if you are grounded in this problem, this social problem of battering, then you already know all the answers to the questions. You just don't know what the questions are going to be, right? So you're not being asked to testify to things you don't know. And if you don't actually know something, you just be honest and say, I don't know the answer to that question. I think it's, we'd like to see this more routinely done in communities around the country because we think that this is helpful to help reduce some of the biases that are out there in the general public about this particular social problem. So, yeah, feel free to contact us if you want.
Thank you both so much. It was really, really good information.
Thank you.
Great, and thanks to all of our participants as well.
Yes, goodbye.
Goodbye.